Welcome back to the deep dive. Today, we are dissecting a concept that sits right at the intersection of personal responsibility and legal liability.
Hmm.
We're moving past the idea of just simple carelessness, what we've talked about before with contributory negligence, and we're moving into the realm of choice. We are talking about assumption of risk.
And it's a fascinating shift in the legal landscape. I mean, if
Hmm.
negligence is about failing to act reasonably, basically just being clumsy or thoughtless, assumption of risk is about looking a danger right in the eye and saying,
Yeah.
I see you and I accept you.
Right.
And traditionally, this defense acted as a complete bar to recovery. If you assumed the risk, you got nothing.
Which feels a bit harsh, depending on the context, of course. So, the core legal problem we're really digging into today is how does the law distinguish between a plaintiff who is just, careless versus one who voluntarily chooses to encounter a danger?
Exactly. And to get there, we have a very specific path for this deep dive. First, we'll establish the definition and the strict elements of the rule, focusing on that subjective standard in the restatement.
Okay.
Second, we have to define what voluntariness actually means legally. We'll use a rather, let's say, messy case called Rush v. Commercial Realty Co. to do that.
I'm looking forward to that one.
Then we'll hit the classifications, the vital difference between express and implied assumption of risk. And finally, we'll get into the modern friction, how comparative negligence has essentially swallowed up implied assumption of risk. We'll center that on the landmark case, Knight v. Jewett.
Perfect. Let's not waste any time then. Let's start with that foundational black letter law. When a defendant claims the plaintiff assumed the risk, what is the general rule?
Okay, so based on the restatement of torts, the rule is this. A plaintiff who fully understands a risk of harm to himself caused by the defendant's conduct and who, nevertheless, voluntarily chooses to enter or remain within that area of risk is not entitled to recover.
And there are specific elements to that, right?
Yes, there are three specific elements that a defendant absolutely must prove.
Okay, let's bring those down. What's element number one?
Element one is knowledge. And this is crucial. The plaintiff must have had actual and subjective knowledge of the particular risk.
How is that different from regular negligence?
Well, in negligence, we ask what a reasonable person should have known. That's an objective standard.
Right.
Here, we don't care what they should have known. We need to know what this specific plaintiff in their own mind actually knew.
Got it. Okay. And the second element?
Appreciation. So the plaintiff has to understand the magnitude and the implications of that risk. It's not enough to just know this is dangerous. You have to appreciate how it's dangerous and what could happen.
And number three?
Voluntariness. The plaintiff has to voluntarily choose to enter or remain in the area of risk.
Okay, that third element, voluntariness. It sounds simple on the surface, but legal history suggests it is anything but. I want to look at the test case for this. Rush v. Commercial Realty Co. from 1929. This case has some very distinct imagery.
It certainly does. It really forces us to define what choice means in the eyes of the law.
Let's analyze Rush v. Commercial Realty Co. First, what are the legally dispositive facts?
All right, so the plaintiff, Mrs. Rush, was a tenant. She had occasion, as the court so politely put it, to use a detached outhouse that her landlord provided.
Okay.
Now, she knew the floor of this outhouse was in bad order. She was aware of it, but she entered anyway. The floor gave way, and she fell 9 feet into what the court called the accumulation at the bottom.
The accumulation. Wow, that is an absolute nightmare scenario.
It truly is. She had to be pulled out with a ladder.
And what was the core legal issue here?
The issue was this. Did Mrs. Rush's knowledge of that bad floor mean she voluntarily assumed the risk? And if so, should that completely bar her from recovering any damages?
So what rule of law did the court apply here? Could you state the full black letter rule and break it down into its elements for us?
Sure. The court applied the rule of assumption of risk, but focused on voluntariness. The rule is, to assume a risk, the exposure has to be voluntary. And here's the key part. If the plaintiff has no reasonable alternative, the action is not considered voluntary.
So the elements are still knowledge and voluntary exposure.
That's right.
Thank you. Now for the court's elemental analysis, let's walk through this step by step. How did the court apply that element of voluntariness specifically?
Well, the court basically did a mini-analysis just on the concept of choice. The sub-issue was, does a tenant really have a choice when they're using the only facility available to them?
Right.
And the court's application was very pragmatic. They noted Mrs. Rush was, and I'm quoting again, impelled by the calls of nature.
Mm-hmm.
She wasn't required to leave the whole property to find a bathroom, and this was the specific outhouse the landlord provided.
So even though she physically walked in there, from a legal standpoint, she didn't really choose to.
Exactly. The court's finding was that she had no choice. Therefore, her action was not voluntary. It falls into this gray area of actions that aren't, forced by a threat, but are unreasonably difficult to avoid.
And after that analysis, what was the court's final conclusion?
The defensive assumption of risk failed. Because her encounter with the risk was deemed involuntary, she was not barred from recovery.
So if you're forced by the calls of nature and your landlord's negligence, you aren't assuming the risk. That makes a lot of sense. Now let's pivot to the second classification. That was implied assumption, but what about when you actually sign your name on the dotted line?
Ah, yes.
I'm talking about express assumption of risk.
Waivers and contracts.
Exactly. If I sign a waiver, is that always a complete defense for the defendant, a get-out-of-jail-free card?
Generally, yes, it's very powerful. The rule is that express assumption of risk is a complete defense, but only to the specific risks you agreed upon. However, and this is a major however, it can be invalidated if it's contrary to public policy.
Okay, and what does that mean?
It usually comes up when there's a huge disparity in bargaining power.
Let's test this exception with Tunkel v. Regents of University of California.
A classic case on hospital waivers.
Let's analyze Tunkel. So first, what are the legally dispositive facts?
Okay. A patient, Mr. Tunkel, was being admitted to the University of California hospital. As a condition of getting admitted, he had to sign a document. And in that document was an express agreement assuming the risk of medical malpractice.
So he was basically waiving the hospital's liability for any negligence.
That's exactly what it was.
And what was the core legal issue?
The question for the court was, is an express waiver of liability for negligence by a hospital actually valid and enforceable? Or is it void because it goes against public policy?
And what rule of law did the court apply? Can you state the full rule for this public policy exception?
Of course. The court applied the public policy exception rule. And that rule says, agreements to assume the risk of negligence are invalid if the service is essential to the public, and, critically, there's a decisive disparity in bargaining power between the two parties.
Thank you. Okay, now for the elemental analysis. How did the court apply that public policy test to the facts of this case?
The court really looked at the nature of the service. Medical care is an essential service. I mean, it's a practical necessity for pretty much everyone.
Right.
And its application of the rule focused on that bargaining power. A patient who needs care has little to no choice but to accept the terms the hospital gives them. You can't really bargain. And that creates a gross disparity.
So the essential nature of the service basically strips the consumer of any real power.
Precisely.
Yeah.
The finding was that this kind of waiver violates public policy because it's forcing the public to trade away their fundamental rights just to get a necessity.
And what was the court's final conclusion?
The holding was that the express agreement was invalidated. It was void. The patient did not assume the risk, and so the lawsuit could go forward.
It's good to know hospitals can't just have you sign away their duty of care. Okay, now we need to shift gears to probably the most complex topic in this module. We need to talk about implied assumption of risk and what happens to it in a world of comparative negligence.
This is where the tectonic plates of tort law really collide.
So set the scene for us. What is the modern friction here?
Well, traditionally, implied assumption of risk was a complete defense. You knowingly walked into a danger, you recovered zero. Simple as that.
A total bar.
A total bar. But then comparative negligence comes along and says, wait a minute, we should just reduce damages based on fault, not bar them completely.
So does comparative negligence just kill assumption of risk?
In the modern majority trend, yes, it sort of absorbs it. But to understand how, we have to use these two terms, primary assumption of risk and secondary assumption of risk.
To explain this, we have to look at the landmark case, Knight v. Jewett. This is the California Supreme Court case involving, of all things, a touch football game.
A quote-unquote friendly game that went very wrong.
Let's analyze Knight v. Jewett. First, can you lay out the legally dispositive facts for us?
Sure. The plaintiff, Knight, and the defendant, Jewett, were playing in a co-ed touch football game during halftime of the Super Bowl.
Okay.
During the game, the defendant was playing very aggressively. He knocked the plaintiff over, accidentally stepped on her hand, and severely injured her finger, which eventually had to be amputated.
Wow.
So he argued that she assumed the risk just by playing the game.
And what was the core legal issue?
Does a plaintiff's participation in an active sport like this constitute an assumption of risk that completely bars recovery? Or should it be treated as comparative negligence, which would only reduce her damages?
And what rule of law did the court apply here? Please state the full rule distinguishing primary versus secondary assumption of risk.
Okay, the court established what's called a bifurcation. First, there's primary assumption of risk. This applies where the defendant owed no duty to the plaintiff or didn't breach the limited duty they did owe. This is still a complete bar to recovery. Second, there's secondary assumption of risk. This applies where the defendant did breach a duty of care, but the plaintiff knowingly encountered the risk anyway. This gets absorbed into comparative negligence.
That's a very technical distinction. And there's a specific sub-rule for sports, isn't there?
Yes, the sports rule. It states that co-participants in a sport owe only a limited duty to refrain from reckless or intentional conduct. They are not liable for ordinary negligence.
Thank you. Now for the court's elemental analysis. Let's walk through it. How did the court apply the duty element in the context of primary assumption of risk?
The court looked at the nature of the activity itself. In active sports, vigorous participation and accidental contact are expected. They are inherent to the game. So the sub-rule is that liability only attaches for conduct that's totally outside the range of the ordinary activity.
And how did they apply that to Mr. Jewett's behavior in the game?
The court found that while the defendant was maybe negligent, he was playing rough, for sure. His conduct wasn't reckless or intentional. It wasn't totally outside what you might see in an aggressive game of touch football.
So because he wasn't technically reckless, he didn't breach that limited duty they owe to each other.
Correct. The finding was there was no breach of the limited duty.
And after that whole analysis, what was the court's final conclusion?
The court held this was a case of primary assumption of risk. And because it was a no duty, or rather a no breach case, the plaintiff was completely barred from recovery. She got nothing.
This distinction is just so vital. So if it's primary, the defendant basically did nothing legally wrong, so you lose. But if it's secondary, the defendant was wrong, but you were also risky, so you split the bill.
That's a perfect way to put it.
I want to really cement this idea of the scope of the risk, that subjective knowledge part we talked about at the very beginning. I need some visceral hypotheticals. Give me the amusement park scenario.
Okay, let's call this one the flapper versus the spikes. Scenario A. You get on a moving belt ride, something like the flopper from that famous old case. You see jerking people around, making them fall. You get on, the belt jerks, you fall.
And the analysis.
You subjectively knew the risk of motion. You appreciated it. You assumed that specific risk. Recovery is barred.
Okay, pretty straightforward. Now change the facts.
Scenario B. You fall on that same ride the exact same way, but when you land on hidden spikes that are sticking up out of the floorboards. Analysis. You assumed the risk of motion and falling. You did not have subjective knowledge of hidden spikes. You didn't appreciate that specific risk. Therefore, you didn't assume it. The park is liable.
That makes the subjective part crystal clear. One more. The human kite case.
Right. Let's call this the incompetent driver hypothetical. So scenario, you're a stuntman. You agree to be strapped to a huge kite, which is then pulled by a car to make you fly. Analysis. You definitely assume the risk of gravity. You assume the risk of the wind changing, a gust hitting you. But unless you knew about it beforehand, you do not assume the risk that the driver of the car is drunk or totally incompetent.
You assumed the risks of the kite, not the driver.
Exactly. The scope of the risk is key.
Excellent. Now, we've covered a lot of ground. I want to synthesize this for the listener who might be staring down a final exam or maybe a complex legal brief. Can you give us a diagnostic checklist? How do we attack an assumption of risk problem?
Absolutely. Here is your step-by-step diagnostic checklist. Step 1. Check for express assumption. Is there a contract? Is there a waiver?
Okay.
If yes, you have to ask, is it void for public policy? Remember, is this an essential service with a huge disparity in bargaining power? If it's your gym membership, the waiver is probably valid. If it's a hospital, probably not.
Step 2.
Step 2. Check for implied assumption. Now you're looking at the plaintiff. Did they know the risks subjectively? Did they appreciate its magnitude? And, importantly, did they voluntarily encounter it? Remember, Rush, if there's no choice, there's no voluntariness.
And step 3, the big modern analysis.
Step 3, apply the primary-secondary test from Knight. You have to ask the critical question, does the defendant owe a duty? Check the context. Is it a sport? If so, the duty is limited only to avoiding recklessness. Check their status. Is it firefighter's rule? Professionals can't sue for the very negligence they're hired to fix.
And what are the results of that test?
If the answer is no duty or no breach of a limited duty, then it's primary assumption of risk. That is a complete bar. Game over.
But if they did breach a duty?
If the defendant did breach a duty, they were negligent, but the plaintiff knowingly encountered it anyway, that is secondary assumption of risk. And in that case, you merge it into comparative negligence. You assign a percentage of fault, you reduce the damages, but you do not bar recovery completely.
That is the roadmap. We've gone from the bad floor of Mrs. Rush's outhouse all the way to the rough play of a football field. It really seems like the law is just trying to balance respecting our choices with a mandate to keep people safe.
It is. And if you take one thing away from this deep dive, let it be this. Always ask duty first. So much of assumption of risk is just a confusing way of saying the defendant didn't owe a duty to protect the plaintiff from that specific risk in the first place. If there's no duty, there's no tort.
A provocative thought to end on. If you assume the risk, are you really just absolving the world of its duty to you? Something to mull over. Thanks for listening to this deep dive.